This document is a last will and testament, otherwise known as a simple will. This document will be used if you require probate. It is how the court makes disposition of your assets that you own when you pass, unless you have other mechanisms in place to avoid probate. So in this will, in Article 1, Paragraph A, we reference the spouse's name. We state that there are no children. In Article 2, you can make a request for burial or cremation, and we reference a separate document that you'll sign called an appointment of agent for final disposition. In Article 3, we talk about specific gifts. We include all tangible personal property, and we reference a memorandum that we've included at the end of the documents, and I'll point that out to you as well. Any specific gifts that you make will be included here. For example, if you're passing real property to someone, or if you have a vehicle that you're giving to someone, or if you have financial accounts that are passing outside of probate, that will all be confirmed here. And then Article 4 is what we call the residue, and it is everything else that is not specifically given away will pass, in this case, in equal shares among two people. Your residue may look different. In Article 5, we build in a retirement benefits trust for some added flexibility when you are leaving tax-deferred money to non-spouse beneficiaries. And we will discuss that more in depth as it applies to your particular situation. In Article 6, we name personal representatives and trustees of any trust that we might create in this document. We waive bond for them in Paragraph B because we trust the people we've named and we don't want to require them to do that. Paragraph C authorizes your personal representative and trustee to pay your final expenses, as well as authorizes them compensation for serving in that role. And then Paragraph D says if you require probate in a different state, either the folks that you've named can serve or they can nominate someone else. Paragraph E discusses how co-personal representatives can act. And Paragraph F says that either one of them can act independently. We're not going to require them both to perform everything together. Paragraph 7 goes into detail about the powers that your personal representative and trustee have to wrap up your estate for you. They are broad. They may include things that don't necessarily apply to you today, but the goal is if they need to do it, it is included as a power here. And you'll see similar powers in your durable power of attorney document. Those powers are actually good during life, while these powers are good after death. They include everything, including making bank transactions, buying and selling real property, buying and selling personal property, accessing digital accounts. Then we get to miscellaneous provisions. The first one is a spendthrift provision. And what that says is even though you have named beneficiaries in this document, if those beneficiaries have creditor problems, they can't reach your assets to satisfy their claims. Paragraph B says that any beneficiary is entitled to at least an annual accounting. Paragraph C requires that anyone inheriting from you must survive you by 30 days in order to inherit. Paragraph D defines descendants. Paragraph E defines discretion. Paragraph F defines incapacitated. Paragraph G references the Internal Revenue Code. Paragraph H defines heirs. Paragraph I provides that Florida law governs. And then we sign this document in the presence of 2 disinterested witnesses and a notary. This document does incorporate that memorandum. So here, if you have items of personal property that you would like to give to someone that's not the default in your document, that's not otherwise specifically given away, or for example, you want a piece of artwork to go to a friend to the exclusion of whomever it is you've listed as your beneficiaries, you would just describe that item here and list the person that you want it to go to. Anything contained in this memorandum does supersede what is contained in your will. And at any time, if you change your mind about who you've left items to in this document, you can just shred it, start a new document, just make sure you date it, sign it, and keep it all together. And this altogether is your simple will. So this document will live in a protective sleeve in the portfolio that we prepare for you. The reason why we put it in a protective sleeve is when you pass, this document actually does get recorded in the public records, or deposited rather, with the clerk of court. And if you open probate, this document does become a public record. So, but during your lifetime, there is nothing that you need to do with this document except for put it in a safe but accessible place.